Let's talk about our top story. A big day happening in Denton, Massachusetts as jury selection kicks off in defendant Karen Reed's retrial for the death of her boyfriend, Boston police officer John O'Keefe. Over 100 jurors have been summoned to report to court today, and this process could take weeks. Earlier this month, Judge Beverly Cannoni denied Reed's request to delay the start of her trial.
I'm not going to grant the motion, all right? We have jurors coming in that were summoned months ago. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury, because obviously that's when jeopardy attaches. And we'll take it from there, but we will start April 1st with impanelment.
So Reed's retrial is going to look a bit different than the first time around. So there's going to be an extended buffer zone put in place. You know that shot we always take in front of those courthouse stairs where lots of action is? Well, that's all gone now. Also, there's a new attorney on the defense team added recently. Well, two new attorneys technically, but one of them added very recently who served as a juror. She was not a deliberating juror. She was relieved of her duties. She was an alternate, but she has been added. And she doesn't practice criminal law either, by the way, if you were wondering. All right, so who's going to be an ideal juror for Karen Reed and for the Commonwealth of Massachusetts? We have a tremendous power panel to talk about this. Let's welcome these brilliant ladies in. With me, former prosecutor Melba Pearson, retired FBI special agent Jennifer Coffindaffer, and podcaster and host of the Roberta Glass True Crime Report, Roberta Glass. Good morning to you all. Melba, I want to start with you, please. As an attorney, looking at both of these sides, who would be the ideal juror for the Commonwealth and then for the Reed team?
So good morning, ladies. And I think this is going to be a very tough one from the standpoint that you have to be basically living under a rock to have not heard about this case. So to find a juror that has not heard about this case at all is going to be virtually impossible. But what both sides are going to be trying to do is to find out whether or not the potential juror has any preformed ideas or preconceived notions as towards guilt or innocence. So anyone who is sitting there that already is like, Karen Reed is not guilty, end of, or Karen Reed is absolutely guilty, end of the story, both of those jurors would be bad people, in other words, for this particular case. And I think also both sides may be interested to know about potential jurors' feelings about law enforcement, because I think that's going to play a critical role as well. If you don't believe anything that law enforcement says because you've had negative experiences, that'll definitely influence the way that you'd be looking at the facts of this case. And also the opposite is true. If you're somebody that always believes law enforcement and has a strong feeling or attachment towards law enforcement, you might be viewing the evidence in a skewed manner as well. So those are some of the things I think both parties are going to be looking for.
Yeah, great points, Melba. Jennifer Coffindaffer, the stealth juror concern that the Commonwealth surely has. Your thoughts on that, and also whether this additional attorney could be helpful in possibly picking the ideal jurors for the Reed team.
Well, good morning, Julie and panel. First of all, I think that it's going to be very difficult to avoid a stealth juror getting on. They will be practiced. We know the questions. They have been out publicly, so they can go ahead and practice what they will or will not say. What I think is really important is that the counsel really watch what and how these individuals are responding to these questions. That's going to be key to try to figure out if they're lying or not. So I'm hopeful that there will be good individuals there to scope that out. As far as the defense's brand new attorney that was on the prior jury, I don't know if she'll be really that helpful. First of all, she's not even a criminal attorney, as you well pointed out. And second of all, I think she's there more to give guidance regarding some of the points that should be made that hit home with the jurors in the previous trial.
Great points, Jen. Thank you for that. Roberta, last but certainly not least on this point about the jury selection, I wanted to ask you about something. I enjoyed listening to you so much about how you really dive in and have talked a lot about illusions that have been presented in this case in particular to try to convince the public. And when you think about it, who's really in that jury pool? I'm wondering if the people who are at home, not at that courthouse, not engaging in spewing hate online, I'm wondering if those people are going to come out and present themselves as the fair-minded, honest, good citizens that you would want on a jury who aren't looking to take the case one way or another. I'm wondering if we're just not hearing from those people, if that's going to be our pool. Curious, who do you think is going to get picked for the pool?
Well, I mean, we think that everybody, when we talk about true crime, follows true crime, but not everybody follows true crime or even court TV. So we're looking for someone not who so much doesn't know about Karen Read, but doesn't have a set opinion and can look at the evidence in a fair-minded, rational way that doesn't think, what if something really improbable happened, and hasn't been touched or influenced by Karen Read and her enablers' innocence fraud campaign.
Exactly, Roberta. You want somebody who's not going to have been influenced or looking to tank the case in any way. And I'm just wondering if what we see, we see people outside, and sometimes the most obnoxious and loudest people, are not the reflection of the community. And Roberta, I'm curious, you've talked to a lot of people, done a lot of interviews and work on this case. Curious if you think what we see out there is truly a reflection of the community in Denton.
Oh. I think some of it is. I think she does have some support, but I think it's probably exaggerated. I think it's a very well-crafted, well thought out, well funded, certainly, propaganda campaign. I think most people, I think most people are curious about the case, and I don't think the majority are the Free Karen readers. No, not in that community. Although I do think she does have her supporters. Yeah.
Roberta, thank you for that. Excellent points. Here's what I want to do. I want to play for you all a clip that has really circulated and gone viral. Dave Portnoy, the head of Barstool Sports and the owner of Miss Peaches, who's beloved online, has taken notice of the case and started talking about it. Let's take a look.
Get ready with the Karen Read stuff. You just said she's guilty, so just get ready for that crowd. That's the craziest crowd of all.
Are you afraid of Turtle Boy?
Me? No, I'm friends with. No, Turtle Boy and I are buddies.
I didn't. I said I would not vote her guilty, but if you gone ahead, I think she did it.
I think the weirdest thing of all is she's doing this right now.
It's crazy.
That's what I don't get.
She does seem fairly unsympathetic that the guy's dead.
Okay, so that was just a portion of the conversation. Melba, you were just hitting on how you have to be living on another planet to have not heard about this case, and especially after the investigation discovery doc, more and more people are digging in and weighing in on this. Would you mind speaking to the idea that I think it's often overlooked? It's okay for someone to have heard about the case or thought about it or, maybe formed an opinion. What isn't proper in having someone on a jury?
Well, what's not proper is for you to come in already with your mindset as to what the verdict is. Because remember, when you come in to a case, what you hear, what we see reported on court TV and other outlets is not the entirety of the case. You're not necessarily hearing every single piece of evidence that the juries heard in the first trial. We heard bits and pieces and all of that. So when you're actually the juror on the case, you have to have a completely open mind and listen and evaluate the evidence and compare that to the law, and then make a verdict based on that, not based off of what a podcaster said or what you heard a commentator say or whatever the case may be. Just listen to the evidence that's in the courtroom. So again, it's okay to have heard of the case. It's like any high-profile case, whether it's Diddy, whether it's Henry, Epstein or Weinstein or any of these high-profile cases, R. Kelly. You would have heard of them, but you just cannot have already formed an opinion as to their innocence or guilt.
Exactly, Melba. You can have thought about it, but once you take on that oath and that service, you have to say, okay, I'm willing to let go of anything I previously thought or might have thought I believed and just totally judge the facts on the evidence. So to your point, Dave Portnoy could be on this jury if he could say, look, I can follow the law. I can, you know, I might have had some opinions watching that documentary, but I'm going to be a good citizen and listen to the evidence and judge the case therefrom. All right, we're not done talking about this. Our power panel staying with us. We're going to hit our first break. When we come back, we'll talk about the big ruling that came down yesterday from the court on that third-party culprit defense that Karen Reed's team has been trying so hard to put forth. Talk about a key ruling ahead of Karen Reed's retrial. This could be tipping the scales in jury selection even. Judge Beverly Cannone ruling that the third-party culprit defense that the defense wanted to do with young man Colin Albert has been denied. They cannot try to point the finger at him. Now, the judge said this is because they failed to show there was any evidence that Colin had any motive, intent, or opportunity to kill Officer John O'Keefe. What's more, there was no evidence he was even at 34 Fairview at the time that John O'Keefe was there. The judge said, in citing Karen Reed's right to a fair trial, that she is going to potentially allow them to point the finger at Brian Higgins or Brian Albert if and only if they can support their claims. She wrote, quote, counsel cannot mention potential third-party culprits in opening statement, but will be given the opportunity to develop the theory throughout relevant evidence at trial. So she's taking that incremental approach that she did last time, essentially saying, if you can put forth the evidence to substantiate your claim, then in the end, I'll give you the jury instruction on it. But remember, the first time, they couldn't do that. They couldn't do that, so they didn't get the jury instruction. Let's take a look back at the first trial. Alan Jackson arguing about the defense theory, accusing Colin Albert as being a suspect.
The Massachusetts State Police should have, if they were doing their due diligence, they should have investigated this young man. They should have investigated every single person that was in that house, in or around the home of where John O'Keefe was found, the Albert home, and they didn't. They did nothing to investigate whether or not there was someone in the house who tended to fight, who wanted to get in physical altercations, who had a propensity to get in physical altercations, who was a fighter by nature, who threatened to fight, who threatened violence. That's what this young man has indicated he does constantly. I'm surprised he didn't show up in this hearing with busted knuckles.
So does this go to your third-party culprit defense?
It goes to both. It certainly goes to both, but yes, it also goes to our third-party culprit defense as well. This is a focus of, I believe, this should be a focus of the jurors' attention in terms of, is there a third party who could have done this? That evidence points to that may have done this. Absolutely, this evidence, what we now have, points directly in that. It's focused in that direction. So yes, both it should have been investigated, and Colin Albert is somebody that the jurors should focus their opinion on or their attention on to determine whether or not he could have or was involved in the death of John O'Keefe.
I'll tell you what sickens me. That young man wasn't even there. And the harassment and the torture and the bullying that he experienced because of these wild, unsubstantiated claims were disgusting. Absolutely disgusting what happened to that young man. Let's talk about this some more. Let me bring in Jennifer Coffindaffer, Roberta Glass, and want to welcome in attorney David Bruno. Jen, let me start with you, please. You know a lot about this. This claim about Colin Albert the first time around didn't come without consequences, did it?
No, it didn't. I mean, this young man wasn't able to go to college because of the harassment he was suffering. He had an opportunity to play football. He wasn't able to do that either. So concerned about the harassment, about being followed, about being really tortured for being a murderer at 17 years old. Yet he wasn't even at the location when Karen and John O'Keefe arrived in the SUV. Also, John O'Keefe never entered, and again, he wasn't even there. And Julie, they showed photos of Colin Albert's knuckles on February 26th, not showing the photo of his knuckles on February 9th, and which were clean. It was just absolutely cool what they did.
Right. And we know John O'Keefe was killed by someone in January, And if they had shown the photo where his knuckles were fine on the 9th, Jen, you're right. That wouldn't have led to all the confusion with the jury that Judge Cannoni is preventing this time around. I tell you what, it makes me nauseated what happened to that innocent young man. And I think he's got a nice lawsuit that he can bring. David Bruno, would you speak to that, please? Oh, we don't have your audio, David. That's okay. Let's see if we can get you repaired. I'll come back to you.
Oh, I'm here.
Okay.
My apologies.
Yeah, back up, my friend.
I
Go ahead.
see it a little differently, Julie, respectfully. I see it through the lens of the defendant. You know, I am a former homicide prosecutor. I sit in the defense chair right now. And the third-party culprit angle is really a constitutional right. And when it's curtailed, it really bothers me. I do understand that there's some factual issues surrounding Colin that would be able to play out in front of the jury. The fact finder could assess the credibility of the particular evidence. Curtailing the Higgins and Albert opening statement too bothers me a little bit, you know, because I think there's a little bit there. Obviously, the injuries on the decedent and how they came to be versus whether or not it was an animal versus whether or not it was the taillight. I mean, that's always in question. And then finally, Julie, also, what she also is not allowing is the arguments about the deficiencies in the law enforcement action. That's curtailing again. They have a retired FBI agent that is there to talk about what a investigation should be, the type of investigative tactics and leads they should be following up, and they're also prohibited from getting into that angle. These are three big blows to the defense. It's going to look very different than the first trial, and it may end differently as well.
David, appreciate your point of view as always. Roberta Glass, let me go to you next, please. Your thoughts on this?
Well, it was quite ridiculous to hear David Yannetti argue in court just because there's no evidence that something happened with any of these three alternative suspects doesn't mean we can't use them. And that's because based on, he used his own case. This was the case Commonwealth versus Finney, the case of Marion Alexander's killer, Roland Douglas Finney, who David Yannetti and his sister Tanis got out of prison after a decade after he served a decade, or more than a decade in prison, and on some very improbable and laughable suspects, and he created precedents with that quite disturbing bamboozle of the courts that he did with getting Roland Finney out. And just like Karen Reed, no one else has been charged or convicted of the murder of Marion Alexander, and just as with no one else has been charged or convicted of the murder of John O'Keefe.
Right.
It's very similar.
Right, Roberta. And, and let's talk about that, because Karen Reed was, blowing the horn as loud as she could about her case when nobody knew who she was or what her trial was. She and her attorney went to the federal government and said, you got to investigate this. There's corruption everywhere. Somebody else did this. My client's being framed, yada, yada, whatever was said. And they found nothing. They found she wasn't being framed. They didn't indict anybody. They essentially, their lack of finding any other evidence that anything else went wrong shows that they got the right person. Jennifer Coffin-Deffer, in light of that, how successful do you think this third-party culprit defense that they want to put on, and though they might be allowed to do something with the two Bryans, is going to be?
I don't think it's going to be successful. Look, to your point, this is rumor, this is speculation. There's not one iota of fingerprint evidence, of DNA evidence, of video evidence, of any evidence that they had anything to do. They have no motive, nothing to do with his death. So it's preposterous.
I couldn't agree more. Hank Brennan has spoken up and articulated very well how, third-party culprit, and David Bruno, let me go to you on this. It's not without rules. Right. You can't just say, oh, I think I'd like to point the finger, at Julie Grant because I feel like it. No, there has to be all sorts of things substantiated in Massachusetts: motive, intent, opportunity. knowing that, how do you think that this is going to play out? I mean, truly, David, with Brian Higgins and Brian Albert, these two veterans who served our country, have served in law enforcement for many years, you know, who weren't even near him that night when he was dropped off at the house. There's no evidence John O'Keefe ever set foot in the home. How do you truly think this is going to play out, David? Do you think it's going to be the same thing as last time, like a big nothing burger?
Yeah, we'll see. Hung jury maybe, or guilty. I can't see them acquitting her. You got to be careful about what you are trying to prove as a defense, because you don't have to prove anything. It's proof beyond a reasonable doubt. It's all on the prosecutor to prove the case. But when you start to go after two individuals like they have, their credibility is going to be at issue too, and we'll just see how this one falls.
Yeah, yeah. Roberta, let me go to you. A last word, please, on Karen Reed and all the talking that she's been doing all over the place. How do you think that's going to affect the trial?
Oh, I think she's turned out to be very unlikable. I think she's turned a lot of people off.
Mm-hmm. Yeah, I agree. We'll see what happens with the jury. It's wonderful having you back on the show. Check out Roberta's podcast, The Roberta Glass True Crime Report. I'll be listening, and we'll have you back soon. Agent Coffindeffer, thank you so much for your time. And, oh, that little cutie pie in your shot. I see a cute little kitty cat. Oh, my gosh. All the animals are always welcome on opening statements. And, David, you're coming with us. We thank you for that, too.